Imagine you own a small grocery store. You have never posted a sign about firearms, never really thought about it. It simply was not something you considered part of running a store. Under a law that was on Hawaii's books until June 25, 2026, your silence on that question had already made the decision for you, and it made it in a way you probably never intended. Every customer with a valid concealed carry permit who walked through your door without you saying otherwise was, whether you knew it or not, committing a crime just by having their firearm with them because the law presumed your silence meant no, not yes. The Supreme Court just struck that down, 6-3, and whichever side of the counter you are on, gun owner or property owner, this ruling changed the legal rules you are operating under, right now, this week, whether or not anyone actually told you about it directly. Quick thing before we get into it. I break down Supreme Court rulings that actually change how businesses, property owners, and everyday carriers interact with each other, not just the headline version. If that is useful, subscribe and turn on the bell. 2 seconds, and let's get into exactly what changed and why. The case is called Wolford versus Lopez, and to understand it, you need to understand the specific legal mechanism Hawaii built, because it was clever, and its cleverness is exactly what the Supreme Court ultimately rejected. Under ordinary, centuries-old common law, anyone has an implied license to walk into a business that is open to the public. You do not need the owner's explicit individual permission to enter a grocery store, a pharmacy, or a diner. That permission is built into the business being open to the public in the first place, unless the owner does something specific to revoke it, like posting a no trespassing sign or verbally telling someone to leave. In 2023, Hawaii passed a law called Act 52 that flipped this presumption specifically for licensed concealed carriers. Under Act 52, a business open to the public was presumed off-limits to a permit holder's firearm unless the owner affirmatively said carry was welcome, through a posted sign, spoken permission, or something in writing. Critics inside the litigation nicknamed this the vampire rule, borrowing from the old folklore image of a vampire that cannot cross a threshold unless specifically invited in. A nickname that stuck precisely because it captured the mechanism so accurately. A permit holder's right to enter armed simply evaporated the moment they crossed into any business that had not gone out of its way to invite them in. It was a clever piece of drafting, because it did not ban carry outright, which the Supreme Court had already made clear states cannot simply do. It just quietly made carry illegal by default almost everywhere a person actually goes during a normal day, unless that specific business had gone out of its way to say otherwise. Jason Wolford, a Hawaii concealed carry permit holder, along with several other Maui residents in the same position, backed by a group called the Hawaii Firearms Coalition, sued. Their argument was straightforward once you see the mechanism clearly. If the list of presumptively off-limits locations covers essentially every ordinary business a person visits during a normal day, a gas station, a grocery store, a dry cleaner, then the law does not really regulate where carry is allowed. It effectively nullifies the permit itself for most practical purposes, without ever having to say so directly, since no legislator ever had to vote on a bill titled Ban Concealed Carry almost everywhere to achieve essentially that same practical result. The case moved through the lower courts for 2 years, and the path it took is worth knowing because it shows this was a genuinely close, seriously litigated legal question, not a rushed decision. A 3-judge panel on the Ninth Circuit reviewed Hawaii's law alongside a similar California law in September of 2024 and split the two in an interesting way. California's version, which only allowed an owner to signal consent through a physical posted sign, was struck down as too rigid. The panel reasoned that requiring a specific sign effectively defaulted the vast majority of businesses, ones with no particular opinion either way about armed customers, into a ban by simple inertia rather than genuine choice, since most small business owners simply never get around to ordering and posting a sign about an issue they have not thought much about either way. Hawaii's version, which allowed consent through a sign, spoken words, or something in writing, survived that same panel's review as a comparatively more flexible approach, on the theory that giving owners multiple easy ways to signal consent meant the default was less likely to simply reflect inertia, rather than a genuine considered choice. Wolford and the other plaintiffs asked for the full Ninth Circuit to rehear the case. That request was denied in January of 2025, and they took it to the Supreme Court, which agreed on October 3, 2025, to hear the case, limiting the specific question to how the Second Amendment applies to privately owned property that is open to the public, without reopening the broader Bruin framework itself. Oral argument, held January 20, 2026, gave a preview of where this was headed. Chief Justice Roberts pressed Hawaii's attorney, Neil Katyal, specifically on the vampire rule nickname itself, asking him to confirm that the historical tradition Hawaii was leaning on really did amount to the old common law idea that a person needs an owner's consent before entering, and Katyal agreed with that framing, which several observers following the argument took as a sign the state's position was not landing the way it needed to, since conceding that your law functions the way its harshest critics describe it is rarely a winning move at the Supreme Court. Legal commentators covering the argument came away describing the court's conservative majority as clearly skeptical of Hawaii's position well before the written opinion confirmed it 5 months later. Here is exactly what the court held, 5 months later, on June 25, 2026. By a vote of 6-3, the justices ruled that Hawaii's default rule requiring express permission before carrying on private property open to the public violates the Second and 14th Amendments. Justice Samuel Alito wrote the majority opinion, joined by Chief Justice Roberts and Justices Thomas, Gorsuch, Kavanaugh, and Barrett, with Barrett also writing a separate concurrence that Thomas and Gorsuch partially joined, addressing specific additional points beyond what the main opinion covered. Alito's opinion walked through the practical effect of Hawaii's law in vivid terms, describing how an ordinary day of errands, exactly the kind of day my grocery store example opened with, could turn a licensed, law-abiding carrier into a repeat criminal without them ever intending to break a single law. The core of the majority's reasoning is that Hawaii's approach inverted a constitutional right into something that had to be affirmatively granted by a third party, and that flipping a right into a permission slip is not consistent with how the right to carry has historically functioned in this country, a framing that echoes similar language the court has used in other contexts to describe why a right cannot be made contingent on someone else's discretionary approval. The historical argument Hawaii actually tried to make is worth understanding in more detail, because this is where the case gets into the specific mechanics of how the Supreme Court currently evaluates gun laws. Under the framework the court set in 2022's Bruin decision, a modern gun regulation has to be justified by reference to the nation's historical tradition of firearm regulation, not simply a policy the government considers reasonable. For years after Bruin, lower courts struggled with exactly how closely a modern law had to resemble an old one to count. In 2024, Rahimi clarified that the government does not need to find a historical twin, an old law matching the modern one in exact detail. It only needs a historical regulation that shares the same underlying principle. That clarification matters enormously here, because it is exactly what Alito's opinion spent much of its length testing, whether Hawaii's specific historical examples actually shared the same underlying principle as its modern default consent rule, or whether the resemblance was too thin to count as a genuine tradition rather than a handful of isolated, dissimilar examples. Hawaii tried to root its default consent rule in scattered 19th century property statutes, including a provision tied to Louisiana's Black Code and an isolated 1893 Oregon poaching law. The majority opinion dismissed both as too narrow, too regionally isolated, and too disconnected from any broader, actual historical tradition of firearm regulation specifically, to establish the kind of nationwide historical practice Hawaii needed to defend a rule this sweeping. A single poaching statute from one state applying to hunting on someone else's land is a meaningfully different thing from a blanket, statewide default rule covering every commercial establishment a licensed carrier might visit. And the majority was not persuaded that the first could justify the second under Rahimi's own standard. Now, the part of this ruling that matters most, if you are the one running a business, rather than the one carrying a firearm. Do not mistake this ruling for a decision that stripped property owners of control over their own premises, because it specifically did not. Individual business owners retain full, complete authority to ban firearms on their own property. You can still post a sign saying firearms are not welcome. You can still tell a customer verbally that carry is not permitted in your store. And if a customer ignores that after being clearly told, they are trespassing, full stop, exactly as they would be for ignoring any other lawful instruction from a property owner. Whether that instruction was about firearms, pets, or anything else an owner has the right to set rules about on their own premises. What changed is only the legal default that applies when you say nothing at all. Before this ruling, your silence as a business owner was legally read as a no. After this ruling, your silence is read as a yes, unless you actively say otherwise. That is a meaningful shift in where the burden sits. But it is not a loss of your underlying authority to control your own property. It never touched that authority at all. It only touched what happens in the specific scenario, where an owner has not made any active choice one way or the other. This distinction matters enormously for understanding how both sides actually responded to the ruling, and their reactions confirm the scope better than any legal summary could. Gun rights organizations celebrated this as one of the more decisive Second Amendment victories of the post-Bruin era, treating it as confirmation that the historical tradition test the court adopted in 2022 continues to invalidate laws that try to regulate carry through indirect mechanisms rather than direct, honest restrictions. Groups on the other side, including Everytown for Gun Safety and its affiliated Moms Demand Action and Students Demand Action networks, did not argue the ruling was wrong on the law or claim it was somehow reversible on rehearing. Instead, they pivoted immediately and specifically toward encouraging individual businesses to voluntarily post their own no firearm signage, distributing template signs and guidance to member businesses within days of the decision, which is exactly the tool this ruling left completely untouched. That response, from the side that lost, is itself strong confirmation of how narrow the actual practical shift is. Nobody serious on either side of this issue believes business owners lost their authority over their own property. The fight simply relocated from a state statute book to individual storefronts, one sign at a time, business by business, rather than one blanket default rule covering every business in the state simultaneously. The dissent is worth understanding on its own terms too, because it did not really argue about guns at all, at least not primarily. Justice Ketanji Brown Jackson dissented, joined by Justice Sonia Sotomayor, arguing that this case was never fundamentally about the Second Amendment, but about a basic, much older principle of property law, the right of an owner to control who enters their land and under what conditions. In Jackson's view, requiring a gun owner to obtain permission before entering someone else's business armed does no more constitutional violence than requiring permission to enter someone's home would, and treating the two as meaningfully different simply because one involves a business open to the public misreads what property rights have always meant, since the public invitation to enter a store has never historically been understood as an invitation to enter armed regardless of the owner's wishes. Justice Elena Kagan filed a separate dissent as well, adding her own additional concerns about the majority's application of the historical tradition test to this specific factual context. 3 justices, in other words, looked at the exact same facts and saw a property law case first and a gun rights case second, a genuinely different framing from the 6-justice majority's approach, and that underlying disagreement, property rights versus an individual right to carry, is not resolved by this ruling. It simply loses 6-3 for now, and is very likely to resurface the next time a similar case tests comparable ground, whether in one of the 4 remaining states or in some entirely new legal context nobody has litigated yet. This ruling's reach extends well beyond Hawaii itself, and this is the detail every reader in a state other than Hawaii actually needs to know. Court reporting on the case identifies 4 other states, California, Maryland, New York, and New Jersey, that adopted similar default rule laws restricting carry on private property open to the public in the years after Bruin came down. The 2nd, 3rd, 4th, and 9th circuits had already been chipping away at versions of this scheme state by state in the years leading up to Wolford, with Maryland's own case sitting at the Supreme Court's doorstep, specifically waiting on this decision. Wolford technically resolves only Hawaii's statute, since that was the specific law before the court, but it sets the controlling legal standard that courts in those other 4 states are now bound to apply, which is exactly why legal observers are already describing the default rule strategy as functionally dead nationwide, even though each remaining state's specific law still has to be formally struck down through its own individual case working through its own circuit. Each of those 4 states adopted a slightly different version of the underlying mechanism, some closer to Hawaii's flexible sign or verbal or written approach, others closer to California's stricter sign-only version that had already been struck down at the Ninth Circuit stage even before Wolford reached the Supreme Court, meaning the exact legal path to striking down each remaining state's specific statute will vary somewhat, even though the ultimate outcome, given this ruling's reasoning, is now widely expected to be the same across all 4. If you are a business owner in Hawaii, California, Maryland, New York, or New Jersey, and you want to keep firearms off your property, here is your actual action step. The tool available to you is exactly what it always was: a posted sign, a clear verbal notice to customers, or something in writing. You simply need to actively use one of those tools now, rather than relying on state law to do that work for you automatically by default. If you are a licensed concealed carrier in one of those same states, your action step is the mirror image. The presumption has flipped in your favor, but you still need to watch for posted signage or verbal notice everywhere you go, because an owner's explicit no is still a fully enforceable no. They simply have to be the one to say it now instead of you needing to locate somewhere that already said yes. Let me clear up 3 specific claims already circulating since this ruling came down, because each one takes something real and stretches it past what the court actually decided. The first claim is that this ruling means concealed carriers can now bring a firearm into literally any building in Hawaii, including schools, courthouses, and government offices. That is false. Sensitive place restrictions were not before the court in this case and remain exactly as enforceable as they were before June 25th. This ruling touched only the default rule for ordinary private businesses open to the public. The second claim is that business owners in the affected states lost the ability to keep guns off their property and now have no recourse. Also false, and worth repeating because it is the single most common misunderstanding of this ruling: an owner's sign, verbal notice, or written notice remains fully enforceable, and a customer who ignores it is trespassing exactly as before. The third claim, more a timing confusion than an outright falsehood, is that California, Maryland, New York, and New Jersey's similar laws are already struck down and gone as of this ruling. Not directly, not yet. Even though the legal writing is now clearly on the wall for all 4, each state's specific statute still needs its own case to work through its own circuit before it is formally struck down, a process likely measured in months rather than days. Step back and look at what this ruling actually settles and what it leaves genuinely open. It settles that a state cannot use a default consent rule to functionally erase a carry permit across nearly every location a permit holder actually visits during an ordinary day, while pretending it never touched the permit itself, a distinction that mattered enormously to the majority, and that Hawaii's own attorney effectively conceded during oral argument when he agreed the vampire rule framing was an accurate description of the underlying mechanism. It does not settle, and was never asked to settle, the deeper disagreement between the majority's rights-based framing and the dissent's property-based framing, a disagreement that 3 justices clearly still hold, and that is very likely to resurface the next time a state tries a different variation on this same basic idea, dressed up with different specific mechanics, but built around the same underlying question of who bears the burden of speaking first, the property owner or the permit holder. For now, the vampire rule, in Hawaii and in every state that copied its basic structure, is dead. What replaces it, sign by sign, business by business, is a story still being written, and it is one that will likely look different from state to state, depending on how aggressively local advocacy groups on either side push businesses to actually use the signage tool this ruling left in place. There is a broader lesson here too beyond the specific outcome in Hawaii, about how state legislatures respond when the Supreme Court closes off a direct path to a policy goal. Hawaii could not simply ban carry outright after Bruin, so it built an indirect mechanism instead, one that achieved much of the same practical effect through a default rule rather than a direct prohibition. The Supreme Court's willingness to look past the formal structure of a law and evaluate its actual practical effect is itself a meaningful signal for any state considering a similarly indirect approach to any constitutional right, not just this one. That courts applying a rigorous historical tradition test are looking at what a law actually does in practice, not simply how carefully its drafters avoided saying so directly. If this helped you understand exactly what changed and what did not, hit like, so it reaches other people trying to separate the real ruling from the exaggerated versions already circulating. Both the version claiming this bans guns everywhere and the version claiming property owners lost all control. And subscribe if you have not, because Hawaii's legislative response and the remaining state court cases in California, Maryland, New York, and New Jersey are all still actively developing, and I will be covering each one as it happens rather than waiting for a single tidy conclusion months from now. Tell me in the comments whether you came into this video as a gun owner, a business owner, or just someone trying to understand the ruling generally, because that tells me exactly which angle to go deeper on next time this story develops further, and whether the next video should track a specific state's response or dig further into the historical arguments both sides are still fighting over.